In the Bill of Rights, we find that the public is supreme in lawmaking process. When it comes to law, to go back to the people, instead he sits himself and his team of advisors. Can we consider that as law without the input of the people? Thank you very much.
Thank you. We'll ask Maina to respond to the extent that are relevant to what you said.
Okay. All right, Honorable Speaker. There are very few questions. I think they were in the nature of comments. Yeah, but I want to. There are some things I need to clarify. First of all, it's not correct that I did not have not raised these issues before. I said to the honorable members, I wrote a 21-page memorandum to the committee of experts on the very issues I'm raising, and I was ignored promptly. So now the question of sovereignty. The question of sovereignty and the power of amendment. Now, the architecture of the Constitution is something you make. It's something a people make, a decision a people make. Some constitutions have what are called equality clauses, meaning that you can't amend them. The problem, and it was part of my memoranda, in fact I'll share this memoranda with you so that you can, I want the record to be clear. I warned that if you make a constitution hard to amend, what happens is the following. If a constitution is hard to amend, you empower the judiciary. Why? Because the price of getting a constitutional amendment is so high, you will get change by going to get a judicial interpretation. So the easier option, if you have a constitutional crisis, is to go to court. Once the constitution is difficult to amend, and now difficult to amend constitutions have extremely powerful judiciaries, which is the American example. The American constitution has been amended 27 times in nearly 250 years. Now, a lot of constitutional change in America, for example, the strengthening of the federal government, is judicial interpretation. McCulloch versus Maryland, Marbury versus Madison. The American cases that enhance the role of the federal government, and even the amendments that were done as part, the interpretation that was done as part of the New Deal reforms, these have come from the judiciary. Because the political price of getting a change through amendment is very high. What happens when you do this? When you do this, politics becomes judicialized. And the people who benefit from this process are lawyers. So political change is then mediated by lawyers. It is not an accident that out of American presidents, about 45% have been lawyers. It's not an accident. So there are consequences. Unfortunately, when you tell people there are consequences, they don't hear you. That if a constitution is difficult to amend, you will judicialize your politics. And you make the appointment of judges become highly politicized, which is where we are right now. I warned that in that memoranda, and I'll share it with you, just to make this point. So so that the constitutional amendment power needs to be balanced with flexibility, political flexibility. And these are the things we need to think about and to debate. I am not saying that they should have the power to amend the Constitution. I'm just saying that it is important to reflect about it. Okay? Now, yesterday when the Prime Cabinet Secretary was speaking, he was detailing the number of times that the executive has not implemented parliamentary resolutions. This would be unheard of in the United States. Because in a presidential system, it is understood that not to accept congressional recommendations, there will be consequences, and those consequences are usually financial. Congress will then take action. It can impound your budget. It can do things to you because you are not implementing its resolutions. So the problem again, we have a presidential system. We are operating as if it's a parliamentary system. Yeah? And if you think about even cabinet. In a presidential system, cabinet as an institution, we don't have cabinet government in a presidential system. Some presidents in the US don't even hold cabinet meetings. You have one-on-one meetings with a cabinet secretary. You call, because the mandate is given to the president. So the president calls the particular cabinet secretary. This is how we need to work. We have this thing as if we are cabinet government. There are cabinet memoranda, there are cabinet views, decisions approved by cabinet. And I'm like, you're not a parliamentary system. So we have to make a decision. Now, the question of organic amendments, I like that suggestion. Again, one of the proposals I made. I said, the reason why we created a Salaries and Remuneration Commission was because of MPs' salary. My recommendation was, you don't have to create a Salary and Remuneration Commission. Just say, that time the salaries of MPs were 2% of revenues. Just say MPs will earn 2% of revenues, no more. If they want to earn more, they increase the revenues. Yeah, I mean, that would be the easiest way to deal with the problem. So you have a clause in the constitution that says you get 2% of revenues, so it is your interest that the economy performs well. If the economy doesn't perform well, your salary don't go up. Then you don't need to have a salary remuneration commission. You don't have to pay. You don't have to pay anybody to be monitoring salaries, and it doesn't even work effectively because the MPs have discovered. You have discovered ways of blackmailing and forcing your wishes on the salary remuneration commission. This is frank family talk. Now the fourth issue on this commission, the last issue, this question of commission and judiciary interpreting the laws. First of all, the problem we have in Kenya is something called judicial inflation, juridical inflation. We think every time there's a problem we should make a law. Yeah, that's what we think. We never ask what is the function the law is performing. We always think we need a new law, so you go and legislate. So we've got too many laws chasing too few things to regulate. So because there are too few things to regulate, we have to keep going to court. So the architecture of commissions is something I agree with you. There are some bodies that must be there, like the Controller, Auditor General, the Controller of Budget, the Auditor General, Commission on Revenue Allocation, because of two levels of government. That's about it. That would be what I think you would need. Thank you.
Thank you. Was there anything to Farah? We'll now take another round.
Oh, Vito. Oh, sorry. Okay. Now, Vito, let me just give you a question of Vito. Again, in the presidential system, remember the president is directly elected. Sorry. Remember that in the presidential system, the president is directly elected. He is the people's representative, or she is the people's representative. So you have what is called the doctrine of presentment. It is not a legislative power per se, but you want, the same way you have the president making appointments and parliament approving, you also have parliament legislating and the president giving a scan, because the president is the people's representative too. The problem is that how we have structured the president's reservation in Kenya actually appears to me to make the president a legislator, because the form in which those communications are given to parliament, they actually communicated in terms of draft bill, which I have a problem with. The president should say what their difficulties are, then let the parliamentary processes draft the necessary changes. That is the problem I have. But the idea behind veto is that you've got a directly elected president just like members of parliament. In fact, the thing about a presidential system is it creates I said it's a dual mandate system. One of the problems it creates is legislative executive conflicts. Because the president will say, I'm the people's representative, and parliament will say, we are also the people's representative. So you can have deadlock. And Latin America has had very many deadlocks. In fact, if there is a graveyard of constitutions other than Africa, it's Latin America. And it's because of the presidential legislative conflicts. So veto is not an unreasonable power, but it can be used unreasonably. So you have to recognize that. Thank you.
Okay. We have 10 minutes on this, so we'll take the last round. Emase, who is the MP there? Honorable? Ma? Okay, you'll be number 2. Made. Okay, the next will be the good lady in the middle. That's Honorable Susan. I can't see that far now. We'll come to the middle. Is that Sunguli? Yes, Sunguli. Then I'll come to the center here. The honorable member, those are 5. Deputy Speaker 6. Now I can't jump you the moment you raise your hand. It's out of order for you to stand up, honorable member. If you raise your hand, is good enough. Yes. I'll give to Kwame. Is that Kwame? Is it? Yes. Kwame, even if he stands, he will look like he's sitting. You know? Okay, we'll finish with you. Let's start 1 minute each because we have time pressure. If it's a question, ask a question. If it's a comment, make 1 comment.
Mine is a clarification, Mr. Speaker. Allow me to draw the attention of Mr. Macharia to the slide on checks and balances.
of access to resources. These communities will always say, we get displaced for governments to access resources. And now, my question is, what is this in the face of constitutionalism, the checks and balances, that we can borrow from Canada and apply also here in Kenya and help us? Maybe.
Thank you. Next.
Thank you.
Thank you, Mr. Speaker. Thank you, the presenters and the discussants. I think my question is very clear. One, I would wish to thank the presenter, and especially the way he presented the two forms of governance, parliamentary and presidential. I think it was well cut, and I think our challenge is when an address is well cut and you want to change it to something else, I think we never get time to discuss the rationale for the change. And most of these changes are cooked in either by individuals with selfish interests or cliques of people with selfish interests. So my key question is there a M&D system in implementation of a constitution? Because if there as the M&D system, some of these issues would be trapped, highlighted, and actually corrected in due time. Because with time, I believe a culture is created when even if the constitution is changed, it doesn't come to the attention of the affected, and other people come and continue implementing the same without any reflection. Like I've seen many times, we are parliamentary, I've seen us being whipped. Then we are presidential. I've seen us being whipped many times. Why are we being whipped if we are presidential? People just choose what is convenient, and I don't think that is in line with the constitutionalism. My second question goes to our...
We agreed on one each.
Small one. It made it very clear that there is no need to, when we are doing constitutionalism to go and check with the hawkers and the banana people and what. But I believe what we have is delegated authority. And we cannot assume once we get delegated authority, we run with it. I think the challenge in participation has been, we want participation designed in the manner experts understand. If we design participation in the manner communities understand, I'm sure they will be able to consume and participate effectively and bring their issues on the table.
Thank you.
Thank you.
The next was...
Mr. Speaker, mine is just one comment, and it's really very exciting listening to the presenter. I think that was really thought-provoking. But I take my inspiration from the comments made by Honorable Farah. And this is just to register appreciation, because, Mr. Speaker, you know, when Honorable Farah speaks and Honorable Mbadi agrees, and there is Honorable Kenyan also emphasizing, and those who are, as you know, as opposition as they came during our time. And, Mr. Speaker, they are saying that there's something that we did wrong. And this is now good because they are speaking as elders away from that time. And this thing that we did wrong was that we delegated our duties to Wanjiko. And the NGOs took over the whole thing. And today the paper we have, the reason why this confusion is there is because we allowed civil society, as we called at that time, and most of them are in government in various parts now, to do that thing. And now they are all saying, we actually went wrong. I think, Mr. Speaker, I just stand as a member of that old generation to say, really, history is good. And I think it is time we answer that lady's question. Do we really keep this constitution the way it is, or do we go back? And lastly, I think, Mr. Speaker, Honorable Farah made another good comment. We don't have the United States here today. Can we go back to the Commonwealth? Forget about the Columbus monkey, which my friend here is saying. Let's just wear our wig, because we got this thing from the Commonwealth, and let us keep our Commonwealth tradition with us.
Thank you, Julius. The next was... Yes, member from Mandera.
Thank you. My question will be to Natalie. I found the composition of senators in the upper house in Canada very interesting. Particularly, you'll find the independent senators group are the largest, 40. And given that this is not the product of the voters, is it a good will from the appointing authority to make sure the independents are more than even the parties? Or is it something that has been designed by law or the Constitution? That is my question. And maybe by extension, in the House of Representatives, you have also mentioned that 10% of the members is held by members born outside Canada. Is that something that was given to you by voters, or is it something that was designed by law and Constitution? Thank you.
Deputy Speaker. Deputy Speaker first, then Kwame.
Thank you, Honorable Speaker. For me, I just want to make a comment largely on the presentation by Wachira Maina. It was very interesting. Took me back to my academic days when we talk about the theory of a parliamentary system and a presidential system. But when I came to Parliament, I was an academic. But having stayed in Parliament, I've learned a lot. It's a different world, and they have a different logic, which is practical, actually, more practical than what we do as an academic. For example, when you say that, that we are being advised by Treasury, when I came, that's the way I thought about it. The Treasury was advising us on how to apply the money. But actually, when I came to Parliament, I realized we had a serious parliamentary budget office with some of the top economists in the country who are advising Parliament. And I thought that's a good innovation that Parliament put in. I realized also on the issue of the appointment of the approval of the CSS, I thought, why would they be the ones approving? But upon coming to Parliament, I realized, oh, there's the check and balance because they are not the ones nominating the people. They have no, Parliament has no power in that. So in itself, it creates a check and balance. Even I listened to the Canadian example where they're saying that ministers come to Parliament to be questioned, to answer questions. They don't actually vote on the motion from what you present. Nobody vote. They only answer the questions and nobody votes on the motion. They answer the questions and walk away. So the chance of them something being voted on wouldn't happen, because then that would be a different procedure. So basically, my learning from listening to you and comparing to the practical experience in Parliament is Kenyan Parliament has come up with its own new theory. So maybe it's about time that we create our own theory as a country. On the issue of having the litigations that are in court, it's got to do with the failure of our independent commissions, as Honorable Badi says. Yes, so it's all that. So I think as we go forward, it's interrogating what do we need to do as a country. Do we create our own theory, or as Emasa says, we amend the Constitution? So I think it's a debate that needs to go on. Thank you.
Thank you. Kwame?
Thank you, Mr. Speaker. My question goes to Wakili Wachira. I wanted to give a comment upon which I wanted his opinion. Number 2/3 gender rule in our election. A very noble idea. But their implementation is near to impossibility. I see it as a constitution which is not implementable, because the same constitution tells us, and I support that when you go to vote anybody of your choice, but the end result must reflect no more than 2/3 for one gender. Is that a possibility? That's my first question, and that calls for it could be a constitutional amendment so that we can be able to do away with this necessity by having a constitution provision which is workable. The last one is just to know if in a parliamentary system the counties would pay the expenses of the senators, or that remains with the national government.
And lastly, is it Tandaza? Honorable Tandaza.
Thank you. Speakers, thank you, the facilitators. I'm seeing the speakers having difficulties in noticing me, and yet if you are to whisper to Wachira Maina, I'll tell you that we were in the same school with him, so at least...
That has no bearing on identifying you.
The question, Mr. Speaker, mine is very simple and straightforward. This animal called public participation, Wachira Maina, in the Constitution, and when it comes to the lawmaking process, it is an animal that basically gives all the powers to the judiciary to decide on which law they want and which one they don't want, because the public participation in the Constitution does not go in defining how far, how many, at what time should it be done. And it means as legislators, the moment we do a law that the judiciary doesn't want, all what they need to cite is that there was not enough public participation. What is the future of public participation, and could this enough be defined so that at one point as legislators we will know that we've done enough public participation beyond being voided by the judiciary? Thank you.
Wachira, you can go ahead. Yes.
Now, this question about do we amend, do we whatever, I think we need to understand what the nature of the problem. If you look at, and sorry to give a comparative example, if you look at how the process of making the South African Constitution was implemented, they began by agreeing constitutional principles. I think there were 35 or 34. They began by agreeing constitutional principles against which the draft constitution was judged. Now the thing about principles, they give you an organizing framework or what it is you're trying to do with law. I was involved, as the Right Honourable Speaker said, I was involved in part of the process of the constitution making in Kenya. The way we went about it is people came with their positions. And what we ended up doing is writing positions into the constitution. So the constitution lacks an organizing theory. I mean, Honorable Shalai is saying we can formulate our own theory. Yes, you can. It's just like you have an automotive theory to guide a car. You can have a flawed theory. Your car will still move, but it will not move effectively. You need to have the right theory about the right automotive theory. Yeah? So it is important, even as we formulate our own local theories and whatever, to be clear that things have a logic. And that if the thing doesn't have the proper logic, you will have difficulties of implementation. Yeah? The Canadian system is a parliamentary system. So ministers standing up is fine in parliament. We are a presidential system. The executive and the legislature are separated. So we have to decide, do we want that way or do we want something else? It sounds as if we want to have a parliamentary system. And when I spoke to the committee of experts and to members of parliament in Diani, I said the evidence around the world is very clear. Democracy does better in a parliamentary system than in a presidential system. We have overthrown more than 135 constitutions in Africa from fundamentally a presidential system. Haiti has had more than 100 constitutions overthrown. Latin America in total has overthrown more than 400 constitutions. Then Latin America borrowed the American presidential system. So the presidential system is fragile. It's got this fragility because it leads to authoritarianism or to legislative executive conflict. But it can also work. It has worked in Costa Rica, for example. So the problem is you can make it work, but you have to be clear what it requires to make it work effectively. So my plea to you is we need to go back to the basics and ask what is wrong with the way we have designed our constitution and what are the solutions. I was telling the Honorable Speaker, this is why members of parliament are paid. It is to provide those solutions. You can, of course, consult experts, and I'm not pitching for myself. But don't go, do not go consulting those experts who declare themselves constitutional lawyers on TV. Some guy is in maritime law, but because he is talking about a provision of the Constitution, Parliament is calling him a the media is calling him a constitutional lawyer. That's a problem with Kenya. The law is very clear, and he's propounding ambiguity upon ambiguity. So parliamentary versus presidential, that question is still out. So how we extricate ourselves from this, we need to have an organizing set of principles about what is it that makes our constitution not coherent. Two-thirds gender rule. I have been arguing for some time now that actually this is not a very difficult thing to implement, because we have politically funded political parties, we have government funded political parties. You can set a criteria for funding, for receiving funding in the from the political parties fund. It is you who legislate, and decide there is a criteria of inclusion, people with disabilities, gender. You can set that criteria, and it will be perfectly constitutional. And you tell political parties the amount of funding you get is going to be related to the following criteria, not just having number of MPs in parliament. I mean, there are things you can do, which the only thing that is stopping us is commitment to it. Okay? Now, the one issue, the one suspicion I have about parliamentary versus presidential is that it is going to be, if you want a parliamentary system, it's going to be very difficult to persuade the Kenyans not to vote for the president. So I think that's where His Excellency was making the point, that the presidential system is a foregone conclusion, because it's going to be very, very difficult. I think the challenge for you is how do we make it work? Okay? Public participation. I am surprised we don't have a public participation in legislation, do we? Yeah, so why haven't we had one? Why haven't we had one to define what public participation is? Then the judiciary will implement according to what you have said. You see, I think sometimes we are expressing helplessness about the judiciary, and I think some of this falls back to us. Remember that the jurisdiction of the courts, other than the constitutionally given jurisdiction, is determined by statute. And who makes the statute? Which you can change. Who makes the statute? Yeah, so why are we complaining? Thank you.
Farah. 1 minute.
Yeah, we had, by the way, we came initially, we started off as a parliamentary system. We started as a parliamentary system in 1963. And then, of course, when we became a republic, at that time we were a dominion. Basically, the Queen was still the symbolic head of the country. Then we became a republic in 64. Then we married the two together, which means Kenyatta, who was a prime minister before that, now became a president, but still had to have a seat in parliament. He still represented the Tondo in parliament. And we lived with that system up to 2002, am I right? 2007?
No, 2010.
Up to 2010, yes. 2013, as a matter of fact, because Kibaki still was coming from Ulaya. He was still a president, but at the same time a member of parliament. You could come into parliament and participate in the debate in parliament if you wanted, which he did during when the budget was being done. Now, let me just tell you something that you need to know. My position is that for I'll give you something about the British Parliament. It says, the Indian Parliament says, as the highest organ of the government, the Parliament holds supreme legislative power and can override presidential veto and alter the Constitution. There is no constitutional court, and the Supreme Court does not have an explicit right to declare a law unconstitutional. That's as far as India is concerned. And that's one, if you remember those lawyers who were here, up until the other day, what we used to have is always referred to the Indian law. Because that's where we more or less came from. Now, when you look at the one of the UK Parliament has unfettered. No court can go and strike down any law that's made by the Parliament, even if it's unconstitutional.
Then they come back to Parliament and say, this law that you have made is unconstitutional, proceed and also change the Constitution to conform with it, so that then no matter when it comes into court, the courts do not get into a crisis. My position is, as far as I'm concerned, is that whether we're going to look for a hybrid like the one we had in the post-2013 and have still the president, but whatever we're going to do, but we need to have a serious discussion by practitioners of the trade. Listen to me carefully. If you want to change certain things and certain procedures in medicine, you don't go and look for lawmakers to do that. You ask the people who practice that field, what do you do with it? If it's accounting, it's the same thing. But for us as lawmakers, we are the ones who are the practitioners. Wachira Maina and many other lawyers out there, Maina Kiai and my old good friends who have not been in Parliament, are practitioners to the extent where they're out there in litigation. They're very different from us. They still don't know exactly how it works in Parliament. That's why Kraiti Murungi and Paul Mite will not come here today and have something that they used to think about when they were not in Parliament. And many of us actually who have had a legal training. My position is that if we don't gain back the sovereignty or the supremacy of Parliament itself, we will be coming back to this thing every other day. And this is the moment to do it as Parliament. And that's why she tells you, by the way, she talked about ministers answering questions and leaving. Those ministers are members of Parliament, am I right? Those ministers in the Canadian Parliament are members of Parliament. We've borrowed the idea of the Senate as the upper house because we thought it was a good thing and we took it from the Americans. But what was the idea? When you look at the historical underpinnings on how the Senate in America came into being, when the first 12 independent countries, 12, or 13 or 12, came together in Philadelphia. Some were very small and some were big. So the issue is that are we going to have a union right now called the United States of America based on population or states coming together? Now to protect that, they said let's have a lower house, which is going to be done on population, but let's have an upper house which is going to have equal representation. That's why Montana has 2 senators and 1 member of the House of Representatives, and California has got 37 members of the House of Representatives and also 2 senators. These are nations coming together. We are not nations coming together. You get my point? We might be a Somali nation, Kikuyu nation, Luo nation, basically like that. It gives that beat right now with the 47 counties. So let's look at all these historical underpinnings instead of adapting some of these things without understanding how relevant it is to us for posterity, for the future. Thank you.
Thank you. Thank you very much for your questions. I'll try to take them in order. We mentioned, one honourable member, the role of the First Nations. Maybe to go back, we're in our 44th Parliament, and our Constitution dates from 1867. At that time, we did not consider the First Nations people in the forming of that Constitution. The primary concern was very much the provinces, and in coming together, just as our colleague mentioned, there was a desire to have appropriate representation of those provinces if they were to agree to form the Government of Canada. We did not consider First Nations, and we are living with the pain and the issues that has caused ever since. We have recently adopted in our Parliament a law about reconciliation to try to correct some of those wrongs. There have been no constitutional changes that have been made so far. That's a very difficult process in our country because of the provinces and the formula to amend our Constitution, which is very complicated. But in terms of minerals and exploration, many of our laws have been written now with a recognition of First Nations rights and with a recognition of their importance over the land and their ownership of the land. And so we have been rewriting many of our laws to include consultation, to include giving some of the money back from extracting those resources to those communities. But it is a very difficult discussion. It's one that is still ongoing. And it's really because of the history of when that Constitution was written and how it did not recognize the role of those self-governing bodies. So we are still living with those consequences. In terms of the question for senators and representation, we've had an interesting history with our Senate. As I mentioned, it was appointed. Traditionally, it is the Prime Minister who appoints the senators, and they've always appointed party political operatives. So a lot of Canadians saw those appointments as favors to people who served well the party, and they were then given a role in the Senate. A few years ago, around 2008, there was a big spending scandal in our Senate where senators had spent money on personal matters inappropriately. I think similar to some of the issues that were in the UK. And this caused the Canadian public to rethink the role of an appointed Senate and the role of the Senate itself in our democratic system. The Prime Minister at the time, who was a Conservative Prime Minister, Stephen Harper, he did actually ask the court, the Supreme Court, if we could change our system to have elected senators. And his belief was that this would change, if the senators were elected and accountable to the people, it would remove some of these issues that the Senate had been having. However, the Supreme Court came back and said because of the way the Constitution is written, the agreement from the provinces to join the Federation, you needed to have a majority of the provinces, 2/3, with a majority of the population agree. Like anywhere, this is very difficult. It was a big challenge, and it was not something that the Prime Minister wanted to consider at the time. Our current Prime Minister, Prime Minister Trudeau, who's from the Liberal Party, attempted to address this problem by kicking all of the senators from his party out of his caucus, de facto making them independent in the Senate, and ever since has been appointing independent senators. There's a panel that makes recommendations to the Prime Minister based on their status in society, their jobs, how they've contributed, and then they are appointed to the Senate. This is not a rule. It's not in the Constitution. It's completely done on the goodwill of the current Prime Minister. And I think what's interesting for us will be whether it returns back to the old model when there's a new Prime Minister. But now with such a large body of independent senators, it would take a very long time to change that balance back to the party system. Finally, there's a question about the representation of 10% of members being from outside of Canada. Canada likes to say it's a very proud multicultural community. That doesn't mean that we don't have issues as well, but we do encourage immigration. We do encourage newcomers to come to our country. 10% is a great number, but it doesn't represent the actual number of people who are in Canada, who are from other areas, or who do represent minority groups. That would be more around 20%, so I would say that's the goal that we would like to reach. At the time, there's nothing written in the Constitution, not in our laws. It's all in the goodwill of political parties appointing members from those communities to run as elected representatives. But we do have a few ministers who are actually former refugees to Canada, and so in some ways we like to think that that shows the success of the system, though there is still work to do. And finally, just to confirm that yes, our ministers do sit as MPs. They represent constituencies. They do vote. The challenge for us, which was referenced earlier, is that we do have whips who do try to whip the vote, and I think that's for us the conflict between the executive and the legislative branch. You have MPs who represent constituents and views, and you have the party that wants you to vote alongside them, and that's been a challenge for us in terms of balancing the executive and the legislative role. Thank you.
A round of applause for our presenter and discussants. Thank you very much, Maina, Wachira, Honorable Farah, and Natalie. I'll now invite the Deputy Speaker to chair the next session. The next session will be topic 6. So we call forward Natalie Foster. You remain where you are, but you move to where Wachira is. You are the presenter. TJ Kajwang and Mala Wangari as the discussants. This is topic 6. Thank you, Maina. You have, you can sit and enjoy the discussions. You're also free to participate. Yes. Deputy Speaker. Eh? Yes, okay. Yeah. She will. TJ.
Yes, Mr. Secretary.
How is Kasarani?
Yeah, we are doing very well.
Jacaranda was where? Part of that reason why I was yesterday. I had too much energy that I didn't want to misuse yesterday. So I decided to. They have already told me they're going to get
No, yes, I wanted to chair. Yes. Yes. My documents will remain here. Okay.
I shall introduce her formally so that it does go on record. Ms. Natalie Foster is a clerk assistant of the Parliamentary Information and Publications Directorate in the House of Commons in Canada. She is responsible for 2 lines of business, including the production of the Hansard and the committee transcripts, as well as the coordination and support of information technology activities for procedural services at the House of Commons. Her teams also provide leadership and coordination in the governance and dissemination of parliamentary and procedural information. Natalie is also a senior table officer at the House of Commons, providing daily briefings to the Speaker of the House and advice to the political parties and their staff directly related to their roles in the chamber. She has worked at the House of Commons since 2008, when she started her career as a procedural clerk in the Journals branch, where she played a pivotal role in transitioning the chamber to a hybrid proceedings during the pandemic. She has also managed teams in the international and interparliamentary affairs at the Table Research branch and in the committees and legislative services branch. She has a degree in communications and political science from the University of Ottawa and a master's, I know you say Ottawa, and innovation in democratic governance in Toronto. I think I should also give the discussants, I think I'll give you a bio later. Let us start with Natalie. Karibu. Welcome, Natalie. I think this is not working. Is it working? Oh, it's working. Okay, thank you.
Good morning again. Addressing you now on a slightly different topic. We'll be talking about procedure, parliamentary procedure, a little bit from the Canadian context, some of the very basics that underpin our standing orders and our rules. And then I'd like to address some of the emerging issues that we've seen from our perspective, but I know that are shared with you based on some of the comments that were made yesterday, and particularly around communications, technology, and the inclusion of underrepresented people, in particular people with disabilities, in our parliamentary discussions and systems. So those are 2 of the big issues facing us today. So first we'll start with an overview at the next slide. I'm sorry, it's not working. Thank you. Of the sources of our parliamentary procedure. So some of our procedure is found in our Constitution, Some is also found in the laws that are done. But I would say the majority of our standing orders are found in the document, the standing orders, which is adopted by the members in the House of Commons itself. We also have our Speaker's rulings, which forms a body of precedent that we very much use in order to see how these rules have been interpreted over time. And then, of course, a body of informal practice, that when the practice is repeated, it actually becomes part of the body of our rules. The importance of precedent in our system is such that we maintain an interpretation over time. And in order to maintain that interpretation over time, we do look back on decisions that were made to make sure that we are consistent. And that consistency allows us as clerks to remain neutral and to ensure that the advice to members reflects current practice. I think maybe something to mention, the most important part of what's found in our Constitution are the privileges and immunities for members. That's inherited, of course, from our mother parliament, if you will, in the United Kingdom. Those privileges and immunities are very important. They include freedom from speech, freedom of speech, freedom from arrest in civil actions, exemption from jury duty or to be subpoenaed as a witness to court for members, and freedom from intimidation and obstruction as members occupy their role. We also have, as I mentioned earlier, the right of the House to regulate its internal affairs, its membership and the discipline of its membership, and to require the documents or that the government provide papers, as I mentioned earlier. So our standing orders are a set of rules that are agreed to by the members themselves. They can and they do change as times change, although we have found that there have been some challenges in that the parties want to always come to a consensus when we change the basis for our rules of order. And that has proven very difficult, as you may know, to arrive at that consensus. They do try to do that in committee mostly, or sometimes in discussions between our whips and our House leaders, who do organize the procedural organization and the legislative program in our chamber. So that has been a challenge for us, but it is something that can slowly happen and change with time and with agreement. It does only require a majority vote to change, so in theory you don't need that agreement. But of course, as these rules underpin how the work happens in the House of Commons, it's very much in the interest of everyone to agree. It is then the Speaker's role to ensure that those rules are followed, that they are respected, and that they are enforced. The Speaker in our system is neutral, does not get involved in political debate, but rather ensures that the system is there and the environment is there to allow members to debate fully and to participate fully in the House of Commons and its work. Then, of course, there are the clerks, the table officers who support this, who can provide advice to members directly. Sure, that's the same in your system, and that your clerk and team is available to give you advice on how procedures work. I would encourage you to use those services. We're professionals that are very passionate about these questions, but we also have a long history of experience, and we're able to give advice on how things were done before and how they could be done now. And so those are services that you can certainly access as a member of Parliament. So we have our permanent standing orders. They exist through all parliaments. We do not have to readopt them at the beginning of a new parliament. But we do also have standing orders that may be provisional, that may be just for the session, or that may be even just for the duration of a day or two. And those would be agreed to usually by the parties themselves. There would be a special motion in the House adopted unanimously, and that would tell us that this is how our debate will go for this day, for this session, or for this period of time. So as soon as there's an election or that period of time lapses, those would no longer be part of our rules. So I wanted to talk a little bit about, without going into too much detail about our procedure, the basic concepts in our system. The sort of idea is that the majority would have their way, but the minority should have their say. And I would say that principle underpins much of our procedure and much of our practice in the Canadian Parliament. So if you think about the decision-making process, whether it's for a bill, whether it's for a motion, they would all go through in our Parliament this similar process. First, there's the principle of notice. Nothing should be debated in our Parliament without notice being given to all members. In most cases, this means 2 days' notice or 48 hours. so that members have time to consider what could come before the House and to consider their positions so that they would be ready for debate. The notice process can only be skipped if there is agreement by all of the parties. So that's a very important part. The second step would be the moving of a motion. So in most cases, it is the government that decides what we will debate that day, as they are part of the legislature, as I mentioned. They're sitting MPs. There's a minister who is the minister called the House Leader. That minister decides what we will debate each day. They consult with cabinet and they decide what legislation should be given priority. And then that motion is published so that all members are aware of what we will debate, whether it be a motion in the legislative process or a standalone motion. Most debates have rules about how long members may speak. I would say generally members have 20 minutes to make speeches, followed by 10 minutes for questions and comments, but that time can be split or further divided or shortened if the member only wishes to make a short statement. So that's, of course, the process of debate. Once the motion is formally proposed, debate may go on. In most cases, there's no limit on debate, so we would continue debating until all members are satisfied that they have made their views known, and only once that process is finished would we come to a decision. Now, of course, we do have rules that can limit debate, but those can only be invoked by a vote of the House. So it's not something that the government can impose. When they have a majority in Parliament, it is easier to impose, but right now we have a minority government and they would need a partnership with another party to agree to limit debate. In practice, the House leaders and whips have regular discussions and they sometimes agree on timetables, but when it's a controversial piece of legislation, you can see us debating for many, many days before bringing anything to a vote, which is very different from the British system where there's very much a tradition of getting a bill to committee quickly and having the work done in committee. In our system, we actually spend a lot of time debating the different stages of the legislative process in the House itself. And then finally, there is the decision. It can be agreed to unanimously and we move on. It can be agreed to with some dissenting voices and we move on. Or we can call for a recorded vote where each member has to stand to indicate how they would vote. This is a process that takes about 10 minutes. Each member stands one at a time. We call for the yeas, they stand, and the clerks, we call their names, and they record how they vote. Then we would call for the nays and do the same, and then announce the results to the speaker. That process, with 338 members, takes about 10 minutes. It took much, much longer during the COVID pandemic, which I'll get to for some obvious reasons, but that is the basic process. In terms of promoting democracy and good governance, precedent plays an important role for us, as I mentioned, in terms of being neutral and in terms of ensuring that we are applying procedures equally over time. However, when issues come up, we do try to adjust. And a great example is the COVID-19 pandemic, which rocked the world, surprised everyone. We were dealing with many issues, from mental health issues, physical health, lockdowns, difficult economic times, and that forced us to rethink very quickly some of our procedures and how we got things done. But in doing so, we did have to keep in mind some of the principles that are important, such as protecting the minority, ensuring that the minority has their say, even when there's a majority government, to enable every parliamentarian to express their opinion during the course of the study of business. There's also the idea of preventing the unnecessary waste of time. So I mentioned the government does have mechanisms to limit debate, and to make sure that every measure is given the full opportunity for consideration. So those principles had to maintain even as we evolved and adjust in the face of the pandemic. So two emerging issues that I wanted to speak a little bit about from our parliamentary perspective, but I think they relate to what a lot of parliaments have had to deal with recently. First, of course, is the idea of technology in Parliament and how we've managed that. So that, of course, was born out of necessity in the COVID-19 pandemic, but we do have a model of hybrid sittings, which I'll speak about a little bit more. The idea that members can appear virtually as well as in our House. I'll talk about how we got there. And the issue of electronic voting, which had long been very controversial in the Canadian Parliament, but it is a system that we have now. And then I also wanted to talk about accessibility, in particular for people with disabilities. That has become a major issue in the Canadian Parliament, and so I'd like to explain what we're doing to address some of those questions. So technology during COVID. This was very difficult for us, as it was for many. Very suddenly confronted with a pandemic, with a disease we knew very little about. We didn't know how it spread at first or how dangerous it was. But Parliament, being the center of decision-making, of legislation, of approving financing, needed to be involved and needed to be able to make laws quickly and effectively. Our first step at the Canadian Parliament was actually to consult with the House leaders and the whips to find out how we wanted to manage that. And we actually started with a process of having a very limited number of members in our chamber spread out in the appropriate distancing because we weren't able to create the technology quickly enough. They represented the proportionality of the parties, but not all members could participate. The parties assigned which members would show up. Of course, that addressed the issue in the immediate term, but a lot of members were not satisfied with that because, as I mentioned, their role is to participate in debate, to make arguments, to bring forward the needs of their constituents, and so they wanted to be involved. So very quickly, we were forced as a team at the House of Commons to come up with a system to allow all members to participate. So what you see on the screen there are many of our members participating in a virtual meeting of the House. Excuse me. Ministers, the Prime Minister, members of Parliament all had to participate through this method. We had the Speaker present and the clerks present and a few representatives from the parties, but otherwise members had to be online using Zoom. That was a great challenge for members. It changed a lot how they communicated. It really cut off some of the back and forth that you get during debate, and you had to sort of have the segmented interventions. And so members weren't fully satisfied with that. As we learned more about COVID, they then wanted to push for a hybrid model where some members could be in the chamber, respecting distances, and other members could be online. So that is where we went with our hybrid sittings. You see that we've installed some very large screens in our House of Commons setting to allow members to participate online, but then also to allow members to be in the chamber. Currently, we have a standing committee on procedure and House affairs who is considering if we want to make hybrid parliament permanent. They actually tabled their report yesterday in our House of Commons, and they have recommended that we make hybrid proceedings permanent, meaning that members could continue to participate virtually and they could continue to participate in the House as they wish. What we see is that with the restrictions lifting, most members do come to the House, but there are still some members who appear online, and that would be for a few reasons, and there were a few arguments made at committee for why it should be made permanent. Some of those issues relate to the size of our country. It's a very large country. We have 5 time zones. From my home in Ottawa to fly to Vancouver in the western part of our country, it takes just as long as for me to fly to London, England to see my colleagues. That is the scale of our country. So you have members who, when they need to come to the federal parliament, it can take 2 days for them to get there on various flights and trains and cars and all sorts of things, especially when they're coming from the north or from rural areas. And so there is an argument that if you can maintain the virtual parliament and the hybrid idea, some of those members could have a greater balance with constituency representation. They could have a greater balance with their family life. They don't need to spend 2 days driving in. They could maybe take a little bit of extra time because they can come online for their debate. Then they could come into Parliament rather than having to fly in and out every weekend. The other issues that were discussed at committee were around women and their representation in Parliament and the idea of balance. So how do we encourage maybe young mothers, people with families, to participate in a system that demands so much of their time? The committee concluded that if we kept the virtual participation, it would allow mothers or fathers on parental leave to continue to exercise their role as a member of Parliament from a distance. It would also allow more flexibility in seeing their family, and so that came out as a big issue. I think the third issue that came out was the idea of illness. When a member of parliament is ill or has a reason for why they shouldn't be in a setting exposed to potentially other flus or other diseases, in particular COVID-19, they can still fulfill their function. They don't have to take sick leave. So we had a member who had to have a transplant. That member was told by their doctor that they could not be in a room with their colleagues because it posed a danger to their health. In the old system, it would have meant that that member would have had to stay home. But in the new system, that member can continue to fully participate because they can be virtually present in the debates of the chamber or in committee. So for all of those reasons, our committee has decided to extend these provisions, which is very different from what we've seen in other legislatures who have mostly gone back to being in person. Of course, it's not without its challenges. There's still work to do to make sure that members who are online are included. But I think that that's something that the parties are looking at balancing when they consider who will be coming in and who might be staying home. I also wanted to mention very quickly electronic voting. I mentioned that it was controversial in the Canadian Parliament. Many times over the years we've discussed if we want to do electronic voting, and over again the members have said no. The reason for that is because they were worried about the visibility for their constituents. As I mentioned, members stand when they want to cast a vote, and that is all televised. And they feel that that shows to their constituents that they're present and that they're taking a stand on an issue. So the idea of electronic voting has never been pursued. But then, of course, we had a pandemic, and we didn't really have much choice. So originally, like I said, it took about 10 minutes to vote in the chamber. Originally, we had members vote over Zoom, and we had to call the members one by one and ask them how they would like to vote. This took 45 minutes. So you can see that this is a big use of the time of the House. It was a big issue because the opposition would call votes just to block government debates or legislation. And it was very easy to waste an hour just by calling a simple vote on a matter. So once we realized that that wasn't working very well, a motion was passed to ask the administration to adopt electronic voting using the cell phone. So what you see here is an image of what we use, but every member has a secure app on their phone that allows them to vote electronically. They have to be in Canada. You're not allowed to vote if you're internationally, and we have security systems that make sure that's the case. The motion is listed in the app, and then you are asked to vote yes, no, or abstain. And we validate that it's the member themselves voting through facial recognition technology. So you cannot give the phone to a staff member or to a friend, or a family member couldn't vote by accident. It does have to be the member. We also broadcast, as you can see beside there, how members vote electronically. So what we do is we do the vote in the chamber for those that are present. At the same time, members can vote on their phone if they're absent or away. And then we have a computer system that tallies the results for us, and we're able to inform the speaker of the vote. And this process takes 10 minutes. So we've been able to come back to that previous method while including technology. And this is something that the members very much want to keep. Finally, I thought I would mention our accessibility plan. There was a law that was passed in the Canadian Parliament recently that required all government departments, including the House of Commons, to be accessible to Canadians, to members, to the public. What this has meant is that we were required by law to publish an accessibility plan. It's available on our website, and it includes the concrete measures that we're going to take over the next 3 years to address this. So it's everything from physical spaces to how our information is shared and how it's available to different members of the public. So from our perspective, the 3 things that we're focusing on that are in this plan is how we hire staff, how do we include students, how do we include people with disabilities as members of our team so that our team is representative of that voice and able to better inform us of barriers that exist. We are also taking a look at committee witnesses and how we welcome them to Parliament, what is available to them in terms of accessing the physical building, accessing information, and appearing as a witness so that they're comfortable, that they're taken care of, and that they can participate fully as members of society in their Parliament. And finally, another area of accessibility that is maybe talked about a bit less, but that is important, is the use of plain language. So explaining the work of the House of Commons, explaining the role of the member in simple language that the average citizen could understand. That's been very important, and it's something that we're working on. There's a lot of parliamentary jargon, and so the idea to simplify and to bring it back to the basics. Finally, in that vein, work has begun on some videos to try to explain procedure in a more simple and accessible way to the public and even to members. There are complex rules and procedures around, say, the election of the Speaker, so we have a video that explains how that happens. To ensure that the House of Commons promotes accountability and accessibility to all Canadians. So those were the two issues that I wanted to discuss, and I'd be happy to follow up with any questions you may have after our discussions. Thank you.
Thank you, Ms. Natalie. We appreciate your presentation. Honorable members, in the interest of time, we are going to go straight to the presentation by Justice Ibrahim and then have a plenary for both the two topics. Is everyone in agreement? Okay. I think we can let Justice Ibrahim in. I think you may take it. Honorable members, just in the interest of time, as Justice, the Honorable Justice Ibrahim is coming in, I will begin to read his bio, because that's for the benefit of members and not himself. Honorable Justice Muhammad Kadar Ibrahim is a judge of the Supreme Court of Kenya since his appointment as judge of the inaugural Supreme Court of Kenya on the 16th of June 2011, which I had the pleasure to swear in. He is the chairperson of the Judiciary Committee on Elections, having been appointed on the 16th of August 2021 by the Chief Justice. Justice Ibrahim was elected on the 17th of May 2022 to represent the Supreme Court as a member of the Judicial Service Commission. Justice Ibrahim studied law at the University of Nairobi. He joined the firm of Waroi and Mwite Advocates in November 1982 and was subsequently admitted to the role of advocates on the 11th of January 1983. He went on to establish his own practice, Muhammad Ibrahim and Associates, in 1994. The firm subsequently expanded to become Ibrahim and Isaac Advocates in 1997. The firm litigated civil and constitutional cases, specialized in banking law, company law, bankruptcy, commercial law, property law, and conveyancing and insurance law. He was an active member of Law Society, and in 1994, he was elected to the council for a term of 1 year. He has worked with the Kituo cha Sheria, with Kituo cha Sheria, and was a member of the board of the Legal Education Aid Program, LED. He was a founding trustee of the human rights organization Mwangaza Trust until 1994. He is a past member of the Lawyers Committee for Human Rights and current member of the Kenya Magistrates and Judges Association. He was appointed as a judge of the High Court on the 22nd of May 2003 and first served at the Civil Division of the High Court Milimani, Nairobi, from June until July 2003, when he was transferred to the Commercial Division of the High Court at Milimani. In 2004, he was appointed to the newly established Judicial Review and Constitutional Division of the High Court, where he remained until he was transferred to the Eldoret High Court in the year 2006. He was a resident judge at Eldoret between the year 2007 and 2009, and he occasionally was assisting the High Court in Kisii. In July 2009, he was transferred to the High Court at Mombasa, where he also served as a resident judge until he was elevated to the Supreme Court of Kenya. As a judge of the Supreme Court of Kenya, Justice Ibrahim is assigned the following portfolios. 1, he is the acting president of the court in the absence of the Chief Justice and the Deputy Chief Justice. This portfolio is normally assigned to the most senior judge. 2, he is the Supreme Court representative at the Judicial Service Commission. 3, he is the chairperson of the Judiciary Committee on Elections. 4, the Supreme Court delegate to the Judiciary Sharia Circle. He's also in charge of the coordination of the Supreme Court engagement with non-state actors with particular reference to civil society and marginalized group. 6, he's also in charge of the Supreme Court annual reports. And 7, he's also in charge of the Supreme Court library management. And 8, he's also in charge of developing the Supreme Court strategic plan and undertakes also monitoring evaluation of its supervisors. And lastly, he also oversees the establishment of the courts and ad hoc committee on elections. I think what Justice Ibrahim has omitted to say in his profile here is that Justice Ibrahim is actually known to have fought for the current constitutional dispensation that you see, the human rights that you see today. He was part of the first lawyers who are fighting against the treason trials, the detention without trial, and so on. So, Justice Ibrahim, you forgot to say that part about your history. And some of the laws that have been solidified, he argued them as a lawyer. Thank you and welcome, Justice Ibrahim. And he was actually some of the people who were detained without trial at that time for fighting for the freedom of this country. So for that, we should give him a round of applause. He's not just a Supreme Court judge, he's been a human rights activist, and many of us in the profession have a lot of respect for him. Thank you, Judge Karibu. I think we're ready for you.
Good afternoon, all present. The Honorable, Right Honorable Moses Wetangula, Speaker of the National Assembly, the Deputy Speaker of the National Assembly, Honorable Gladys Sholei, the Honorable Secretary General, Commonwealth Parliamentary Association, Honorable Stephen Twigg. There are so many members here, members of Parliament, members of Senate, and many staff members of the Parliament and Senate, and many of my colleagues here. The list is long, but I request that all protocols observed. I wish I could recognize each and everyone who viewed by name, but because of time constraints, and even I don't have the list, I see most people I know here. So thank you very much. Thank you for welcoming me here. I'm here not on my own behalf. The guest who was supposed to come and make this presentation is none other than the Honorable Lady Justice Martha Koome, the Chief Justice of the Republic of Kenya and the President of the Supreme Court. Due to other commitments which happen to need her attendance, personally, she was unable to come. She conveys her regret and apologies for not being able to come today, and she has delegated to me to represent her here. And with your permission, may you allow me to speak on her behalf. This paper was supposed to be presented by Honorable Chief Justice, and it is about leadership. The topic is leadership, behavior, ethics and standards, a perspective of the judiciary. I had a word with the organizers, the secretariats, and I requested that the presentation, which is in writing, be circulated to all the members here for ease of reference, and either both in hard and or soft copies. I hope you have a copy, whether in soft or hard copy. To assist me, just highlight the paper, and at least you know the content of the entire presentation. So, on behalf of the Honorable Chief Justice, Justice Mohammed Ibrahim, will make her presentation. I also happen to be the chairperson of the Judiciary Committee on Elections, and somehow we saw that this program is headed post-election seminar. However, the content of my presentation has nothing to do with the elections, which were concluded in the course of last year. The presidential one, of course we have other petitions going on right now for senators, for governors, women rep, MP, and MCAs. They were still going on, and they will escalate to various courts, possibly also to our courts later. As an introduction, it's about leadership. So a leader, who is a leader? A leader is the person who identifies the need for change and takes the steps needed to initiate change. That might involve identifying the important stakeholders and involving them in the change process, determining possible solutions and the required resources to make the changes happen. And most importantly, leaders inspire others to see the need for change and to participate in finding a solution and implementing it. The paper is a brief rundown of the judiciary's perspective in leadership, behavior, under the sub-items behavior, ethics and standards. Firstly, by examining the constitutional provisions that govern leadership and ethics. Of course, these constitutional provisions emanated from are underpinned under the 2010 Constitution, of which you know so much about, and the basis upon which you have legislated ever since the promulgation of this Constitution. So it's nothing new to you. I'm just rehashing for purposes of our discussion. Secondly, by looking inwards at the judiciary and the mechanisms put in place to maintain high standards of ethics and performance of duties within the judiciary. Thirdly, by looking outwards through the legal framework that guides and observes the conduct of public individuals and entities. It further looks at the disciplinary mechanism and the consequences arising from failure to uphold integrity. The paper also highlights the recovery of assets as a remedy and how it has been utilized. So there will be a brief discussion about these principles as much as they affect state officers who are leaders in the country, and to some extent also an aspect of the input or the perspective of the judiciary of what we try to do to comply with these requirements of state officers, since the judges and magistrates are state officers too. What is the definition of ethics? Ethics as the moral principles that govern a person's behavior or the conducting of an activity. It is the moral principle that govern a person's behavior or conducting of an activity. It also defines as the branch of knowledge that deals with moral principles. And also another definition is that ethical relates to, of or relating to moral obligations that one person owes another in conformity with moral norms or standards of professional conduct. So we can see that ethics is not only about law, but it's about morality. And morality or morals is governed by what society does and what society thinks. Before assuming an office, a state officer must, by Article 74, take and subscribe the oath or affirmation of office and swear or affirm before God and the people and on the basis of the Constitution and the people to obey, preserve, protect, and defend the Constitution, all other laws of the Republic, and in particular to protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. The Constitution at Article 260 creates a distinctive category of members of the society called state officers, who are regarded and idolized as a special pedigree of leaders in society because of the status they hold, and to whom much is given, and therefore much is required and expected. They include His Excellency the President, His Excellency the Deputy President, the Prime Cabinet Secretary, Cabinet Secretaries, members of National Assembly and members of the Senate, judges and magistrates, members of commissions to which Chapter 15 applies, member of a commission, member of a county assembly, governor or deputy governor of a county, or the other member of the executive committee or a county government, attorney general, director of public prosecutions, secretary to the cabinet, principal secretary, chief of the Kenya Defense Forces, commander of a service of the Kenya Defense Forces, director general of the National Intelligence Service, inspector general and deputy inspector general of the National Police, among others. These are the main state officers. Chapter 6, which is a very important chapter, is christened the leadership and integrity. The mandate of all state officers is one of public trust, and all such officers carry the responsibility to serve the people rather than the power to rule them. The most basic principle to guide such officers are expressed in Article 73(2), and I have set out in the paper the particulars, the details of that article, which includes objectivity and impartiality in decision-making, selfless service, honesty in the execution of public duties, declaration of any personal interest and that may conflict with the public duties, accountability to the public, discipline and commitment. All these are principles under Chapter 6. The Constitution in Article 75 makes specific provisions regarding conduct of state officers. It provides that a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids conflict between personal interest. And I've set out all the expectations under Article 75. I've set it out there, and also aspects of the disciplinary procedures that may be invoked when there is digression under Article 76, 77, and 78, sub-Article 2. Now, this is just generally the obligations and expectations of state officers, which includes all arms of the government. Looking inwards, I will just briefly outline the standard of ethics, integrity and conduct that judges, judicial officers, and judicial staff are expected to adhere to. Chapter 10 of the Constitution establishes the judiciary. The various courts and their jurisdictions, as well as the various offices in the judiciary, including the Office of the Chief Justice, Deputy Chief Justice, judges of various courts. The people of Kenya, through Article 159 of the Constitution, entrusted judicial authority in the courts and tribunals established by or under the Constitution. So the Constitution is in charge of all matters relating to judicial authority. And we know the principles that are required to be guided by the judicial authorities. This includes ensuring justice is done to all, irrespective of status, ensuring justice is not delayed, ensuring alternative dispute resolution mechanisms, including reconciliation, mediation, arbitration, and traditional disputes resolution mechanisms which are promoted, ensuring justice is administered without undue regard to procedural technicalities, and ensuring the purpose and principles of the Constitution are promoted and protected. So we have talked about, we also talk about in the issue of the requirements or the criteria for being appointed a judge and the duties under Article 172, which includes, among other things, recommending to the President persons for appointment as judges, advise national government on improving the efficiency of the administration of justice, behavior, ethics and standards. The issue of measures and we have got mechanisms within the judiciary and within the statutes that this National Assembly and Senate have passed relating to the issue of discipline, removal, and so forth, to ensure that those standards that are set out in the Code of Conduct, in the laws relating to ethics are complied with even by the judicial officers. So we have set out under Article 75 the expectations and also the kind of actions that may follow in case there is transgression, as I said earlier. Leadership in the judicial sense is mostly viewed through reference to the cases decided or the jurisprudence developed by individual judges through their decisions. However, more recently, leadership goes beyond the jurisprudence. That is the kind of work, shared leadership, that our Chief Justice is promoting. Many past Chief Justices never applied effectively, with due respect, but our present Chief Justice believed in shared responsibilities and leadership to the extent that for her to effectively deliver service and carry out her functions, she has included judges in carrying out administrative functions and many other functions otherwise which are would have been confined to her role as Chief Justice. So she calls us judges to be her cabinet. So I'm also cabinet. but in the judiciary. Now there is this Bangalore Principles of Judicial Conduct. This is a very important convention, and it settled the conduct required of judicial officers. Under Article 6 and Article 2, subsection sub-article 6, international conventions to which Kenya is a signatory are automatically part of our law, our constitution. For instance, the Bangalore Principles is now deemed to be part of our constitution. International legal standards of judicial ethics, including the Bangalore Principles of Judicial Conduct, which was adopted by resolution number 2006 2006/23 on July 26, 2006 of the Economic and Social Council of the United Nations. This plays an important role in the process of bringing the judges under responsibility. The Bangalore Principles are intended to establish standards for ethical conduct of judges. They are designed to provide guidance to judges and to offer the judiciary a framework for regulating judicial conduct. 6 core values are recognized: independence, which is very critical, impartiality, integrity, propriety, equality, and finally, competence. The Bangalore Principles have been adopted under what we call the Judicial Service Code of Conduct and Ethics Regulations 2020. So it is also part of our laws through legislation. So the Code of Conduct of Judges and Magistrates, Judicial Officers is set out in the Judicial Service Conduct, Code of Conduct and Ethics Regulations 2020. I've set out the main pillars of that Code of Conduct. In the interest of time, I request you to go through that at your own time. I would like to highlight some key expectations which are set out in the Code of Conduct, and these are on issues of moral and ethical requirements, Section 6, independence of the judiciary, Section 7, not only the judiciary but also judicial officers, impartiality, integrity, propriety, and professionalism. Further, judges are prohibited from participating in any other gainful employment. Section 26, it also prohibits against sexual harassment, which is Section 29 of the Code of Conduct. A judge is responsible of his social media activities, Section 12, and should avoid activity that adversely affects his impartiality. So these are aspects of the Code of Conduct that actually you as legislators passed for us and which we have to comply. We also have got the issue of standards. The judiciary has devised ways of ensuring that the judges and judicial officers are delivering the mandate of the people of Kenya. These include the Performance Management and Measurement Understanding, PMMU, which we have submitted ourselves to. All judicial officers sign performance agreements, performance management agreements, and we have a criteria for measuring this, individually, but also in each court level. We also have regular trainings, reporting, digital automation, and case management. I have set out in the article aspects of the performance management and measurement understanding, which we have set for ourselves. And I've referred to aspects of regular training, digital automation, and case management. I have to mention something about digital automation and case management. Particularly after the outbreak of COVID, had we not adhered to or embraced technology and used the digital automation for hearings, we would not have achieved what we have achieved so far. And despite the COVID measures and the problems of meeting physically and the stoppage of physical court processes, we were able to trigger or to set out and implement digital hearings, online hearings. Just now, before I came to this meeting, just a few minutes ago, we had, the Supreme Court had 3 cases of which I participated from in my room, and fully robbed, fully equipped, and we were able to dispose of 3 cases. I was able to excuse myself from 2 others because of my ability or my wish to be with you here, so that, thank you, so that I'm able to keep the promise of the Chief Justice that I must deliver this, this presentation. So you can see how it has helped us, and the efficient disposal of cases. We're able to dispose of and settle so many cases because of this. We don't have always to go to court, and we can deal with cases from anywhere in the country where we have network. We have areas where we have problems of network, but it's a work in progress, and we are trying our best to assist the regions where there are negative, automation network problems. We also do law reporting, which is very important for the public use. We have to do law reporting so that you know, wananchi know, the academia know, legislators know, the case is decided, and the jurisprudence that is being churned out by the judiciary. We also, in terms of law reporting, we have been trying to assist the media to avoid misreporting of our judgments, whereby we, apart from delivering a full judgment and sending it out there, we also do what we call a media summary, because we found out that it's a very important tool. Summary on 1 page or 2 pages of the issues in the case, and the determination and the conclusion, so that off the cuff, at a snap of a finger, the media are able to know, and because once a judgment is published, the media want to disseminate and inform, particularly very sensitive and matters touching on the public, cases that touch on the public. So sometimes, because of the nature of media, because of the nature of sensationalism, they pick a point and forget about the real content of the judgment. So we try to assist them with that, but it's very difficult. Like the last 2 cases we decided about Married Women's Property Act, they totally misled. The headlines were misleading. So I request you to read the judgments on those issues, and you will realize that it's not true that we decided against the interests of women. To the contrary. To the contrary, in those both cases, they were in favor of the women. So just go back to read the whole judgment. We also have the enforcement of standards of conduct and behavior. We have got the Judicial Service Commission, of which I'm a member, representing the Supreme Court. There are ways that we inquire into our own conduct. There are investigations are done where there's a complaint by any member of the public, court users, any parties in a court case about a particular judicial officer. We do investigations, we give them hearings, and discipline is carried out depending on the nature and gravity of the cases, to the extent of reaching up to the recommendation to the President for removal of a judge, if it is at that level. And then, of course, we have got acts of parliament that now, regarding this is now about state officers. We've got acts of parliament that regulate the conduct of judges and magistrates, and there are various statutes which have been enacted to enhance ethics of public and state officers. For instance, the Public Officer Ethics Act 2003 is an act of parliament to advance the ethics of public officers. Now this cuts across the entire public service. And it provides for the code of conduct and ethics and requiring financial declarations from the certain public officers and to provide for connected purposes. There is what we call this annual, every 2 years we normally have to fill out we have to make declarations. I think it applies to all public state officers, the declaration of wealth. Many times we call it the declaration of poverty, depending on your pocket or your bank account. So the Leadership and Integrity Act is another statute, Act number 19 of 2012, which gives effect to and publishes procedures and mechanisms for the implementation of Chapter 6 of the Constitution and for connected purposes. As I had mentioned, we have the Public Officers Ethics Act. I've set out provisions of that. I request you to go through them. I have set out an outline of the Leadership and Integrity Act and what they speak about. Leadership and Integrity Act is an act of Parliament to give effect to and establish procedures and mechanisms for the effective administration of Chapter 6 of the Constitution and for connected purposes. I think you know this very well. You know of the details, and you as Parliament, both the National Assembly and Senate, have invoked these provisions to make inquiries into conduct of not only your members, but other state officers too. We have disciplinary procedures under our law. We have a process for removal of a member of a commission or an independent office. I've given a case, an example, a case of Umkia Mtata Koiti versus National Assembly of Kenya and four others, and four other interested parties, versus including the former Auditor General Edward Ouko and 5 others. The court, in a case challenging the mandate of the National Assembly under Article 251, the court dismissed the petition and held that Article 251 was clear of the National Assembly's mandate to hear petitions for removal of members of any independent office. We have the law relating the removal of governors. You have dealt with it, you have applied it in at least 2 cases. The removal of the governor has been successful twice. It has been utilized on 2 occasions. The case of Mike Sonko Mbuvi, Gideon Kyoko, Nairobi County, and that of Ferdinand Waititu in Kiambu County. So you can see how these laws are working in the interest of the people of Kenya. We have got laws relating to forfeiture and asset recovery. The Asset Recovery Agency, through Proceeds of Crime and Anti-Laundering Act, number 9 of 2009, has recovered assets that have been determined to be proceeds of crime. The records show that this ran into billions, showing the kind of use and importance of this process for recovery of proceeds of crime. The East African, the Ethics and Anti-Corruption Commission, through the Anti-Corruption and Economic Crimes Act number 3 of 2003, has through forfeiture recovered unexplained assets. As of 4th March 2022, that commission has recovered properties worth 30 billion, with the civil cases filed in various courts across the country to recover public assets valued at 14 million. The judiciary has done its role through setting up of the Ethics and Anti-Corruption courts and through hearing of petitions presented to the proceeds, presented under the Proceeds of Crime and Anti-Laundering Act number 9 of 2003 and the Anti-Corruption and Economic Crimes Act number 3 of 2003. We have given an example in that paper of one case, Stanley Mombo Amuiti, and whereby this forfeiture as a form of remedy, a fair remedy, has been applied to recover assets that that cannot be explained, and criminal forfeiture requires a criminal trial and conviction, while civil forfeiture is employed where the subject of inquiry has not been convicted of the underlying criminal offense, whether as a result of lack of admissible evidence or a failure to discharge the burdens of proof in a criminal case. As I conclude, I would say that the role of the judiciary is defined in the Constitution under Chapter 10 of the Constitution, with Article 159 mandating the judiciary to protect and promote the purposes and principles of the Constitution. History provides us with many lessons to be learned from great leaders of the past. There are those who quickly rose to power and showed promise of extraordinary success before ultimately falling into grace. There are those that, despite their great wealth and charisma, were not well equipped for leadership as they lacked honesty, humility, and a servant's attitude towards leadership. There are also those that, despite being wise, were consumed with the pursuit of wealth, fame, and power. The main reason that history repeatedly reminds us is that there is great correlation between leadership and accountability coupled with integrity. Thank you. The judiciary's leadership on perspective on leadership, behavior, ethics, and standards is for it to ensure that constitutional principles in this regard are maintained, not only within itself, but by the very institution of or office working for the betterment of the people from whom its authority is derived. That is the people of Kenya. I thank you, and God bless you all. Thank you.
Thank you very much, Justice Ibrahim. You may have a seat. Honorable members, I'll be seeking your indulgence just for, because we need, I know we should have gone to start with the previous topic, but I'm requesting that we try and finish with Justice Ibrahim's topic. He has been very kind to us by spending the night and transferring his discussion to today. So we'll start with his so that we can be able to release him. But I think we'll have our two speakers make comments. I think, who are we starting with? Ms. Lucas or Kevin? Yeah, just for a few minutes. Yeah, they each said 5 minutes. I think he's under 10 minutes. And then we can, I know you have lots of questions for the judge. So thank you. Yeah, let's finish and then you'll have questions for the judge, yes.
Thank you
so
very much.
So my apologies to my previous speakers. Honorable Natalie, you'll just wait that we finish with the judge first. Thank you.
Thank you very much, Honorable Deputy Speaker. Good morning, Honorable members and participants. Is it afternoon? It's fine. We are still here. We haven't left, at least. Now, if she say we must speak in 5 minutes, and you have initially said you can get 10 minutes, we must now try just to take out the real important issues. But I am supposed to speak about the issue of the code of conduct with regards to ethical behavior of honorable members. And I'm deliberately calling it honorable members, because just the title of being an honorable member should already inform the fact that you are supposed to be a leader that exudes ethical behavior. All of us, as members of parliament, first and foremost, is actually swearing an oath. And our oath of office include that we promise to adhere to the constitution of our countries and also to the code of conduct that we all agree to as parliamentarians. So it is very important that we all adhere to the code of ethical conduct and to the disclosure of members' interests. I saw that the judge has spoken about the fact that we need to declare our interests. He said you need to declare our poverty, but it's fine. It is, I think the issue of interest is a little bit more than just declaring poverty. In the South African context, we have a joint rules committee, and the joint rules of Parliament provides that there should be a committee on ethics that should be comprised of members of both houses of Parliament, and the Code of Ethical Conduct and Disclosure of Members' Interests for Assembly and NCOP members is intended to provide a framework of reference for members of Parliament when discharging their duties and responsibilities. The legislative framework includes the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, and also the Prevention, Combating of Corrupt Activities Act and the Financial Management of Parliament Act, which we call the FAMPLA, just as we used to do. I just want to outline the following principles that members should adhere to, and that is the issues of selflessness. And we spoke about the issue of selflessness, being there to do it for those that have put you into the position, integrity, objectivity, openness, honesty, and also the fact that as a leader that you should lead by example. In terms of the standard of ethics as prescribed in the Code of Ethics, members need to abide by the principal rules and obligations of the Code by virtue of the fact that you have sworn an oath. The members should be expected to uphold the law of your country. On all occasions, members are expected to act with the public trust that was placed in them, and they are also expected to place the interests of the public above their own interests when discharging their obligations to Parliament and the public in terms of the Constitution. Members are expected to maintain public confidence and trust in the integrity of Parliament and in the performance of their duties and responsibilities. They are also expected to be committed to the eradication of all forms of discrimination. We spoke about the disclosures that members should fill out. Within 60 days after the general elections, it is required of members of the South African Parliament to actually fill out an annual disclosure. The kind of financial interests that are registerable interests and must be disclosed is if you have shares and other financial interests in companies and other corporate entities, remunerated employment outside of Parliament, directorship and partnerships, consultancies, sponsorships, gift and hospitality in excess of 1,500 rand in the South African from a source other than a family member or your permanent companion, or traditional gifts that does not necessarily create a conflict of interest for the member. Members should also declare any other benefit of a material nature, including foreign travel, other than personal visits paid by the member or business visits unrelated to the member's role as a public representative, and official and formal visits paid for by an organ of state or the member's party. They should also declare ownership in land and property, including land and property outside of the Republic of South Africa, pensions from your former employment, public contracts awarded, trust and encumbrances. That is the disclosures that you need to do. There is an ethics committee that will deal with address allegations of impropriety, and sometimes any person can make an allegation of impropriety, but it is for the ethics committee to determine whether the member or the honorable member, I want to call honorable members all the time because we are speaking about leadership, we are speaking about our behavior, we are speaking about ethics. And I think just the fact that people are giving us the title honorable should already inform how our conduct should be. I'm just repeating it. So what constitutes a breach of the code? It is when the member contravenes or fails to comply with the requirements of the provisions for disclosing their interests, or when a member deliberately discloses incorrect or misleading details, or even a former member if they breach the code of conduct. So there is a procedure for investigation of complaint, because anyone, even people with ill intentions, can make a kind of allegation against a member, and that is why there is a investigation procedure to make sure that we determine whether there is a real or alleged breach of the Code of Conduct. And that should be done to the registrar, because there is a register of members' interest, and that register is being administered by the registrar of members' interest. So where a member refused to be to receive the service, for him to actually appear before the committee, the chief whip of the members' party should take that responsibility. And members should respond within a very short period of time of 7 days to the kind of allegations. What is the penalties that they can be actually given to members where they have breached one or more of the clauses of the code? A reprimand in the House, where someone stand up and the presiding officer reprimand that person, and a fine that not exceeding the value of a salary for 30 days, a reduction of salary or allowance for a period not exceeding 30 days, or the suspension of certain privileges or a member's right to sit in a parliamentary debate or committees for a period not exceeding 30 days. In event of a breach considered minor by the committee, the member may be ordered to rectify the breach and be counseled on the requirements of the code. Members should employ every effort to make sure that they familiarize themselves with the constitutional provisions that inform members' ethical behavior, the existing national legislation that prescribes ethical behavior, the rules of the House that prescribe ethical behavior by members, and members should not only adhere to the rules for compliance, but should recognize the important role they play in shaping the moral fabric of our society, where often society at large emulates the behavior of members or leaders of society. I only have 5 minutes, but I just want to say one thing. A leader should be disciplined in all aspects. Thank you very much.
Thank you. Thank you, Honorable Sylvia Lucas. Our next discussant is Honorable Kevin Andrews, former Member of Parliament, Australia House of Representatives. A round of applause for our next discussant.
Thank you, Madam Chair. Justice Ibrahim has outlined the constitutional legal provisions in detail, so I will not repeat that, but instead I'd like to address why the maintenance of standards and ethics is important for members of Parliament. And may I begin with a general observation. As members of Parliament, we are seeking together as a group to provide practical answers through legislation and the programs which are supported by legislation to an age-old question, namely, how can we live together? A question which was posed as long ago by Aristotle. And indeed, there's been mention here about working through the Assembly for the welfare of society and the just government of the people of Kenya. So this is an ethical or a moral issue. And this is particularly critical in a democracy such as yours and mine. In discussion and compromise, as we've even heard in discussions about aspects of Assembly business yesterday in this room, different people and different groups will have different answers to the question of how we can live together when talking about specific topics. When it comes to enacting legislation or implementing programs, indeed as even discussed this morning about what sort of constitution and what the provisions of that constitution should be for Kenya. Therefore, relations between members of Parliament and between members of Parliament and the public, like all interpersonal relations, rely on trust. This means that the standards of behaviour need to be based on some uniformly recognised principles of conduct. Otherwise, the essential trust upon which democracy is based is absent. So, regardless of what's written in a constitution or in legal documents or codes of conduct, it's my contention that the ethical standards of behaviour based on trust are actually fundamental to the livability, to the workability of democracy itself. And there are various ways in which we seek to put that in context within a parliamentary system. And Sylvia spoke about, for example, the register of interests, which we have a similar provision in Australia. And those interests include not just property and financial and pecuniary interests, but also interests in relation to membership, for example, of organisations. Because there could be a conflict of interest for a member of parliament, not just in relation to owning of shares or property or trusts or that sort of thing. Could also be a conflict of interest in terms, at least perceived, in terms of the membership of a particular organisation. And so as members of a parliament in Australia, at the beginning of each parliamentary term, we complete a register of interests, which is available online forever. And then any changes to those interests have to be notified to the registrar of members' interests, and they're updated on the online site. There's just one other thing that I wanted to mention in the brief period of time available, which goes to this question of standards of behaviour and the way in which we operate as members of parliament. And that is when our own position on a particular issue conflicts with the views of at least some of our constituents. And this happens from time to time, and it happens for all of us. We represent constituencies of people that have a whole range of interests on a particular matter, yet we, as members of parliament, have to come to a decision about what you're going to do on a piece of legislation. Some constituents will disagree with you, some will agree with you. I've always taken the view that it's the Burkean view expressed by Edmund Burke, I think in about 1770, when he said, "Your representative owes you not his industry only, but his judgment, and he betrays instead of serving it if he or she sacrifices it to your opinion." In other words, you're elected to a deliberative assembly, that is the parliament, in order to come to a judgment, to work hard, your industry, but also to come to a judgment about what is the appropriate thing to do on behalf of your constituents, some of whom will agree with you and some of whom won't. And of course, being a large electorate, in Australia's case, our electorates were about 115 to 120,000 people, there's no way of knowing generally what the views of your constituents collectively are on a particular issue. And I can remember constituents writing to me saying, "You're my representative, so you should vote this way." On one occasion I got a letter like that from one constituent. 2 days later I got a similar letter from another constituent saying I was his representative and I should vote the other way. So I just wrote back to them and said, "I've had 2 letters from 2 of my constituents telling me I should vote this way and that way. At the end of the day, I will vote the way in which I make a judgment about, and you, of course, can vote against me at the next election." And I think that's the only way in which this can work. This was complicated, if I can finish on this note, on an issue in the last couple of years in Australia, where, as in many parts of the world, debate has been on the definition of marriage. Should marriage be defined as a union between a man and a woman, which was historically and traditionally the common law situation in Australia? I could have made a judgment on that, except for the fact that there had been a plebiscite held, or a survey, if you like, of all Australians on their view on that, and a majority of my constituents actually voted to change the law and to expand the definition of marriage. My conscientious view was that I wanted to maintain the definition of marriage as between a man and a woman, yet in this case, I did know what the view of a majority of my constituents was, and that was that they wanted the vote to change. The only way which I could, in good conscience, I believe, resolve that issue for myself was simply to abstain from voting on that legislation. I knew there was a majority of members of parliament who would vote for it in any event, so I didn't stand in the way of the views of my constituents, but as a matter of conscientious views of my own, I could not bring myself to vote for that legislation. It was contrary to what my conscientious views were, and so I abstained from voting on that particular legislation. But that was very rare, because in most cases, you don't know what the collective view of your constituents are, and therefore you have to make a judgment about that. But making a judgment, having listened to the constituents who want to put their views to you, and there will be various views, obviously we have an obligation to listen to them, to discuss these matters with them, but at the end of the day to make a judgment based on all of those views and based on your own reasoning as to what you should do on a piece of legislation. I will leave it there. Thank you.
Thank you very much, Honorable Andrews. And I think now we can start the plenary. I think I saw Tiende there. Over here, Ruth Nyamai. Let me pick one from each row. Honorable Member, my eyesight fails me. You're behind the rectangular. No, sorry. Wanyonyi. Who else? Yes. These are the front row. But I think, Honorable Rosso, you had a chance in the previous one. I think the Ferdinand Senior there, Wanyonyi, has not had a chance, so I'll give you an opportunity. I will come to that last row. Yes. Yeah. My eyesight is not as good as it used to be, but I'm still in denial. Yes. Okay, we'll start with those ones first, and then we'll come back. I know I haven't, the row of Honorable Kaluma, I haven't come to you. I'll come to you. Thank you. We start from the farthest. You want to go first? Oh, yeah, I picked you first. Let's start with the Honorable Amolo Tiende. Yeah.
I want to thank the Honorable Justice Ibrahim, the Honorable Sylvia Lucas, and Honorable Kevin Andrews for that presentation. I think it raises interesting issues, which if we had time we could have focused on. But allow me to ask only one question of Honorable Justice Ibrahim. And you know, the disclaimer, the injunction here is Justice Ibrahim has been my friend for a long time. I agree with the presentation, Justice Ibrahim, in terms of behavior, ethics, and standards. But I want to raise a concern in terms of the ethics of the judiciary as an institution. There's a growing perception by members that the judiciary is exhibiting hostility to Parliament as an institution, but particularly to the National Assembly. And we can discuss that on various grounds. Of particular concern, Justice Ibrahim, you're aware that there's currently a case pending in the High Court involving the CDF, case number 178 of 2016. And the issue of concern is the Honorable the Chief Justice, well aware that the matter is pending, made or makes a public pronouncement declaring that that act is unconstitutional when even the High Court has not made it, which then leads the minister and others to say that they cannot and they should not release monies. Now, from an ethical perspective, what avenue of redress would we then have? Because the Office of the Ombudsman of the Judiciary, which I have established, is an administrative office under the Chief Justice. The Judicial Service Commission deals with matters of a certain level, but is also chaired by the Chief Justice. So this poor litigant, and in that case that is all of us, in the High Court, when the Chief Justice has declared that the act is unconstitutional and 3 judges are waiting to hear and make that decision, is it not adverse to those litigants, and is that not unethical? And what is the avenue of redress? Thank you very much.
On your right.
Thank you very much, Honorable Deputy
Sergeant,
Speaker.
I'll take to the mic to the next person, because you must have an extra one. Continue.
Yeah, so let me first of all thank the Honorable Justice Ibrahim Mohammed for a very good presentation and the discussants. My concern is on separation of powers, the 3 arms of government. In the trainings that we have had within the time that we have been in this house, is that we have realized that other jurisdictions have respect for the separation of powers, especially where we have a situation where we have a bicameral situation, like the one that we have in Kenya. And we realize that in those jurisdictions, when a matter comes that concerns the 2 houses, the courts keep off. They decide not to take action. They say, go sort out your issues in Parliament. Do you think we'll ever get in a situation where our judiciary decides to keep off matters to do with Parliament so that Parliament can make decisions, especially where there is a coalition or sibling rivalry between, for example, the National Assembly and the Senate? And Justice, for us to get there, who do you think can raise the voice? Do you think it is a training that will happen at the a judiciary? Because we think that is where interference is coming from. Thank you very much for the opportunity.
Thank you. I'm Shendrak Mwiti, MP South Menti Meru. Thank you very much for fantastic presentation. Mine is just related on the issues between the gap between the judiciary, parliament, and the ethics. In various cases, we have seen that there is a gap or no relationship, or we find that the decisions made or the judgments made in the High Court, contrary to what the allegations are from the ethics. What are you doing, Justice Ibrahim, to mitigate the relationship, to reduce the expenditure or the loss of revenue by the government on various cases that are not well handled? Thank you.
Mine was a statement, a question to the presenter from Canada. But linked to that, April, I think you are here on the behalf of the Chief Justice. Kenyans, and on behalf of the people sitting here, are tired of these busybodies. You actually, the courts are taking busybodies more seriously than what these members of parliament do. My own experience is that I've noticed that you're taking more time with the busybodies more than what we actually are doing on the behalf of the Kenyans that they elected us. And I wish you were there listening to the presentation from Canada, which was well presented. And I was just going to ask her, and that she's not there, I was going to ask her, she says they change the standing orders any time something comes up new. But I think all I'm saying is, please, my expression is that we're tired of busybodies. They're tracking us behind. Thank you.
Thank you very much to the presenters. My name is Mashua Idaka from Kiambu Town Constituency. My question is to Justice Ibrahim about Chapter 6 of our Constitution, which talks about implementation.
Please introduce yourself for the benefit of the judge. Waidaka, isn't it?
Yes,
yeah?
Mr. Mashua Idaka from Kiambu Town.
Proceed.
Yes, Chapter 6. My question is to Justice Ibrahim about Chapter 6 of our Constitution, which talks about implementation and the requirements of leadership, integrity, and the values required of any public leader. And we find that when public leaders misbehave in public and are not in line with the requirements of Chapter 6, when they are taken to court, the courts don't seem to punish them. Why is this so, Justice Ibrahim? Has Chapter 6 been overridden by our politics? And how? And is the judiciary vulnerable? And can it not work properly? That is the first question. The second question is about the judiciary. How do we hold our judiciary accountable to the Kenyan people? Because you find that the executive is accountable, is held accountable by MPs through oversight. Parliament is held accountable by the people and also by the judiciary. But how is our judiciary being an independent institution accountable to the people? Judges like the EAC have security of tenure. You cannot do anything to them without a long, tedious process. Because sometimes you find the case dragging on forever. And who holds the judiciary accountable? How do we hold the judiciary accountable to the people of Kenya? Thank you.
I think Justice Ibrahim will allow you to answer those, and you can actually do it from here if you choose.
Thank you, the Honorable Chair, Honorable Gladys Boss, for the questions that have been asked by members. There are quite a number of questions which have been raised, very complex ones, and maybe even sensitive. But I'll speak for myself. I'll speak for myself to the best of my ability. There's one or two questions I may not have understood, so I may request the speakers to assist me to confirm whether I took the right notes. Regarding Honorable Senior Counsel and Honorable MP for Arieda, my brother Amolo Tiende, you have put me in a very difficult position, but I'll only speak on the issue of principle. On the issue of principle, I'll not talk about individuals. It is clear law that if a matter is pending in court, ongoing, that is required as much as possible, any member of the public, including even the members of the judiciary, if a matter is pending in the High Court, even the Magistrates' Court, Court of Appeal, or Supreme Court, or any other court for that matter, if there's a matter pending, it is active, we refer to the principles of sub judice. This principle of law is that the citizen, the individual, is not supposed to comment on any matter pending in a court of law, trying to interfere with that independent process, trying to intimidate, trying to direct how it should be decided. Unfortunately, in Kenya, it started mainly with the members of the public and particularly the media. Found that matters are pending in court, but then the media will publish comments, criticisms, and even predictions, and even try and speculate how a decision may go, or how the decision may be decided. So we try to discourage the discussions of matters pending, so that we allow the judicial officer to decide independently. I would believe, with due respect, Honorable Amolo, I can't remember the comments that you're referring to, but it appears I respect you because you will not create a picture that maybe, or say something which did not happen. So I'll give you that benefit that this was said. It would be unfortunate for any judicial officer to comment on a pending matter. I don't know at which stage the CDF case was in the High Court, but subsequently I do know that it came to us, and we decided, and you're not very happy with me or my court, but I'm told that possibly the guidance we gave you, because we said this thing is possible, but there's a way that we could come in within the boundaries, ambits of the Constitution. Many decisions we've done and said it's just the procedure was used, not that the idea was bad, the intention was bad. I would regret that one of us could comment on a matter, particularly if one of us was holding that position. I don't have the details, and I hope it didn't happen, but now you have raised it in this forum, particularly when we are in the JSC, when the Ombudsman is domiciled in our courts. So where do you go? That's the question I'm understanding. One time you were the Ombudsman, but this office was taken away from being a commission or independent commission, and now it is domiciled in the Constitution. So you are Amolo, you are an officer of the court. We have relationships. You are our senior counsel. Sometimes you could come and ask personally the person who made such statements, and then you'd have a tete-a-tete, the two of you. But now I can't talk so much beyond this. But I've said about the principles of sub judice. Honorable Rachel Nyamai, sorry, MP Kitui, we need to respect the separation of powers. We are the first, the judiciary is the first one to always cry out that they need to be left independent. We don't want the executive to interfere with us. And so we should be the last persons to interfere with other independent arms of government or even the independent institutions like the commissions. Things like advisory opinion. Many times the disputes between the Senate and Parliament have come to us through a request by one of you for advisory opinion. Under the Constitution, a state organ can seek our advisory opinion. But we always say, before you come to us, please, for heaven's sake, go to the AG, because the AG is the advisor to government on any legal issues. So state organs are part of government. So there is a requirement, and this is a practice. You have heard us adjourning cases that unless the AG has refused to give his opinion or has given and you don't agree with that opposition, then you cannot come to us for advice. But in this case, Senate is the major complainant in disputes between National Assembly and the Senate, because they think that you're very oppressive. The National Assembly is very oppressive because of their numbers or because they are next to the Wananchi directly. So they've come to us several times for opinion, and even the AG has given authority for us to proceed or has given an opinion which National Assembly may have declined to accept the opinion. So we are compelled by those. But one principle is very clear, and I think this answer will answer the other questions of other members of Parliament. The judiciary should not interfere with proceedings going on in Parliament. Law-making, legislation is a reserve of Parliament and Senate. So we have no mandate to interfere with that process at all. And if, I'll say that for free, And we have, as Supreme Court, we have set aside judgments of the High Court whereby there's an attempt to interfere, to stop proceedings in their track, yet the matter has not been finalized. Lawmaking is for those two bodies, but once they are done, once it is done and the legislation made and the acts of statute or statutes have now come to pass, or rather become law, then at that stage, if it is allegedly in breach of any provisions of the Constitution, one can come now and challenge in the High Court and even later in other courts as to the legality of those bills under the Constitution. And sometimes it's unfortunate. We disagree on whether that statute is legal or not, but we are empowered if we are of the view that you have exceeded the application of the law in passing a law, then we try and correct that, we nullify that, or declare a statute unconstitutional, null and void. That is inevitable. It is our role. But even if there's apprehension during the proceedings that likely you are going the wrong direction, we cannot come there. We can't enter the chambers and stop you until you finish, and now the test is whether you complied or not. Then it is for the courts to interpret. Until then, they cannot interfere. So if we have done that, that's wrong, and I hope that my court would not do that. But we always corrected the other courts from time to time. Mheshimiwa Mwiti, I must confess I didn't understand your question. Could you assist me?
Somebody give him the mic. We need the microphone, please.
Just summarize.
Thank you. My question was related to know why the legislature, the judiciary, they are not reading from the same script. You fight in various times that the parliament intervenes on issues related to the ethics. The ethics presents allegations that end up in parliament. Thank you.
I think, in general, to answer your question, I think I remember in the first time you asked the question, you were talking about the relationships between the parliament and the judiciary. And regarding ethics, I believe generally, if Parliament carries out its roles effectively, and the judiciary does their part without interfering with each other, I think we are complementary. Our duties are complementary to each other, but as much as possible, we don't interfere with each other. The judiciary is accountable, is required to be accountable, and that's why in certain offices, before you take a judicial officer takes office, we must come to you to be cleared, what we call vetting. The Chief Justice, Deputy Chief Justice cannot take office. Why? Because we are accountable to the people of Kenya, whom you represent. And when you have taken it personally, you have accused of some of us, before we are accepted to take office, to be sworn in, you have accused us of previous bias, even corruption. So we are accountable, and we are subject to the law. We are accountable. The judiciary is accountable through check and balances with the parliament, through the legislations. All this code of conduct that you're seeing have been passed by yourselves. So we're subject to the laws you have passed. And even the issue of the complaints against judges, disciplinary against judges under the Judicial Service Act, Judicial Service Act, and the Judiciary Commission, Service Commission. All these have been passed by you, and we applied strictly. We have recommended judges to be removed. And the magistracy is not, they don't have security of tenure. We have disciplined magistrates, and they have been terminated, they have been reprimanded. So all I'm saying is that so long as we comply with the law, all of us, then there should be no room for either stepping on each other's powers or even disregarding the law and even the law relating to ethics, as you have said. I don't know whether that has answered your question. Mr. Honorable Onyonyi Ferdinand, you talked of being tired of busybodies. But you didn't mention any particular busybody. But we under the Constitution of Kenya, any taxpayer or any Kenyan can virtually bring any constitutional issue to court. In the old days, we used to call such people as busybodies or volunteers. But nowadays, the law is so, gives power to any taxpayer to question us. You have seen the way that and it has worked, it has been good. Have you seen that NGOs promoting public interest matters, they have come and they have obtained judgments in favor, orders in favor, in the interest of the public. You know this famous senator called Omtata. He has come to court. People thought he was a busybody, but he achieved so much and assisted the law to grow. And now even his people have given him honor to be a member of the Senate. So I think while it has its negative side, but it's something that we cannot stop, and I think it has played a good role in our jurisprudence and in the expansion of our democracy. I don't know if that's what you meant, Honorable Onyonyi, but we try to avoid people who bring flimsy cases, cases that are not justified, that may waste the time of the government. And even, I know how you are very sensitive about injunctions. A single judge, ex parte, without hearing you, or the government for that matter, gives an injunction which has massive implications. It stops transactions of major magnitude being stopped, involving finance and involving matters of investment. We have tried as much as possible to discuss this among us and to guide ourselves as to which cases we cannot give ex parte orders, and we allow the Attorney General or whoever is aggrieved to come and participate and oppose such proceedings before it is, without having to do it ex parte in the absence of the other party. So I think Honorable Waithaka, Kiambu MP, you talked about Chapter 6. I think I've answered you partly that the judiciary is accountable. We are willing to be confronted with their criticism. We are willing to change in case we make mistakes. That's why we have got this appellate process. Sometimes the only court that may not be subject to another court maybe is the Supreme Court, but we have got mechanisms for review sometimes. And also, in case we talk through such fora, like here, and you to point to us how we went wrong, we will be very careful next time that we don't repeat or even try to avoid such a situation. So accountability is there. If we fail to do so, you have a right to question us, even in Parliament. In Parliament, you can question the judiciary anytime. The security of tenure, your privileges allow you to criticize us and to actually even recommend laws that can bring change. One time you were so unhappy with us, and some of you are questioning whether the Supreme Court of Kenya is necessary, whether they need to continue existing. And we were very worried for a while about that, but you spared us. So these things are workable, and it's just a question of listening to each other and cooperating with each other. I hope I've answered most of the questions or inquiries. Thank you so much. The chair is here.
Thank you, Justice. Before we take another round of questions, we'll get Honorable Sylvia. Or we take the... Okay. We will take one more round. Honorable Raso, then we'll have Honorable Elachi, then we'll have Honorable Jared, then we'll have Honorable Kaluma, and finally Honorable Musa.
Thank you very much, Chair. Thank you, Justice Ibrahim. My question is the lack of progress in our law or in our judiciary. When we watch the TV, people have something like the People's Court, where small issues actually are settled rather than going to look for a lawyer, to go to a full-blown court session, and it saves a lot of resources for both the individual and the country, and it saves time. Why are we not looking at such things? Finally, it's about the judiciary and the Constitution. Our judiciary, they are using the Constitution as a working document as opposed to a reference document. Why am I saying this? Something like CDF is a public good. The Kenyans have become accustomed to it. And it is also seen to be a moral fund. Are we going to slave ourselves to the Constitution that does not address to some of these things, or the court must travel outside these boundaries that have been defined by a written document to actually address what is good for the country? Thank you, Madam Deputy Speaker.
Someone get the mic to Honorable Elachi. Switch off any mics that are not on. That's embarrassing that you're actually rising. Okay.
Thank you very much. Thank you, Justice.
The next person is Honorable Jared, then Honorable Kariluma, then Honorable Sirma. Can the mics be next to them? Thank you.
Thank you. One is a comment, Justice, that I think it is important for the judiciary, as much as you normally say you will not want to mix with people because people will think when you're in court you are coerced or whatever. I think it is important for the judiciary, first of all, just to go to the government school and just go through some of the policies that we do within government so that we understand each other between government policy and how judiciary works. And I think we will come to a smaller gap in how we understand each other and how we do things in our country, Kenya, using the same constitution, by the way, Justice. But having said that, there is this matter. The matter is still on CDF. A matter was brought in court. The same team that came to court stayed for 7 years in court with this matter, and then all of a sudden, again, the same matter is back in court. Same prayers, same team. How does the judiciary now look at such a matter? You've come to court, the Supreme Court talks about it, then these guys come back again with the same matter and start again at the High Court. I mean, in that matter, I think it is supposed to be thrown out of court because, first of all, they manipulated the court to stay with the issue until you spoke on it, and then now they've come again to execute the same matter, same team, same prayers. I don't think it is fair, even to Kenyans, to taxpayers, and even to the court itself. So I would wish you go and look at this matter of a same team who is now in court looking again for justice on the same matter that stayed in court for 7 years.
I think I'm next. Madam Deputy Speaker, I thank you. Judge Ibrahim, thank you for your presentation and your two discussants here. Now, my first question, and there are two very short ones, is I would want you to tell me if there is any difference between decentralized funds and devolved funds. And by decentralized funds, I mean money from the executive through the national government to the ground. And the devolved funds are known to the counties. So if you tell me the difference between the two or they are similar, I would want to know. Secondly, and this is most important to me, it is usually said that it is not what you say, but how you say it. I mean, people can talk, and people put issues into perspective in a way that is acceptable within our norms. I remember when my brother, President Obama, was president, and yeah. And there was hostility between the Muslim world and America. And he traveled all the way to Egypt and made a speech that tended to unite the two warring factions, if you were to call it. And the way he put his speech was so convincing. The words that he used, starting by Assalamu alaikum, you know, it brought out the unity and cohesion within these warring factions. Now, our Constitution puts a lot of emphasis on ethics, as is espoused in Chapter 6. And ethics is not just about conduct, it's also how you communicate. I cannot go on the streets of Nairobi and start abusing people as a leader, yet there is a heavy expectation from the electorate on how I conduct myself. Now, the Supreme Court is the apex court. It is the top court. I mean, no court can challenge the decision of the Supreme Court unless it challenges itself by Regulation 2, Subregulation 11. And there is usually a very thin line upon which a court can review its decision. Very thin. In fact, I tried it in 2017. I couldn't make it. You guys threw me out early in the morning because it is a very thin line for any court to turn around its decision. Now, when a court of law with such a degree of expectation puts a judgment with certain words that really don't unite a nation, words that if used by a lower court, for example, the magistrate court or a high court, then that court would be cited for contempt, and an action will be taken against such a judge or a magistrate. Now, what happens, therefore, if it is the Supreme Court coming up with certain words that really do not infuse cohesion, does not produce a level of integrity, decorum, so that even if somebody loses at any court, you lose with your dignity intact. But if a court uses certain words, I mean, this can happen to you. Let me tell you, today it is me, tomorrow it will be you. So we must put things into perspective.
Honorable
so,
members,
in
I
a nutshell,
give him his time, let him...
in a nutshell, like hot air, like chasing a wild goose, like
to make
all
a
those
question,
words.
comment, or statement.
So what
So
therefore happens to a litigant? Because when we lose, people go to court to either win or lose. But even if I lose, I want to lose with some level of dignity within me. So if What therefore happens to Supreme Court judges? Because if as I said, if it happened to a lower court, the Judicial Service Commission would cite that magistrate for contempt, and an action will be taken against that judge or magistrate. Now, what happens to you at the Supreme Court? What do we do? Because the same person sitting at the Judicial Service Commission as the president is the Supreme Court Chief Justice. Now, what do we do? I thank you.
Honorable Kaluma.
Yeah, thank you. I had 3 questions. One has been asked by Honorable Jared, but I think he didn't put it more directly. Honorable Judge Ibrahim is a judge I've grown, and I doubt that was his language. And now, because he's there, could the judge confirm to us whose wordings were those hot air fool's errands, and what action has been taken by the judiciary against that judge? But on a more universal one, we have this issue of gender balance, and I am referring to our speakers from other jurisdictions. And the question to South Africa, Canada, and our presenters from the UK, how do you secure gender balance under a fast past the post electoral system like we have in Kenya, where you have the people electing and whoever wins goes to parliament, not proportional representation? Speaker, if you would allow me, my colleagues here are banding words, so allow me to make this statement. Judge Ibrahim, we thank the Chief Justice for sending you. These people would have had a lot of difficulties with the Chief Justice here. And I'm telling you this as somebody who is here for the judiciary most of the times. The National Assembly is not happy with the judiciary as an institution. And I think I'm speaking for you. We may go all round, but this is the thing. And they are unhappy because they say, this is the house which legislates for the judiciary. This is the house which budgets for the judiciary. This is the house which oversights the budget of the judiciary. This house bends backwards on very many issues. And this is the house which approves the Chief Justice and even the Deputy Chief Justice. But any action, howsoever trivial, concerning the National Assembly taken to the judiciary, more so on original jurisdictions, the High Court and the Supreme Court, the National Assembly consistently loses them. Consistently loses them. And so as a defender of the judiciary within this parliament, I'm requesting you, I know I should not send you, to let the Chief Justice know that the executive may promise you 3 billion per year, but unless these members pass it, you may not see it. This is fact. I think we should engage. The executive may promise you retirement benefits for judges, but unless these people here legislate it, it will not be there, and not even the Senate will do it. My fear is that if we continue without reconciling these positions, there will be difficulty between the judiciary and this house that they need most. There is a way this house thinks the judiciary is aloof. I mean, when Supreme Court Judges as Otiende Amolo was saying, and I'm just standing Deputy Speaker, and I'm not talking about the Chief Justice. You see, Honorable Judge, even your decision on CDF was being made when the other High Court matter is pending. And albeit the Supreme Court goes making decisions on the CDF Act of 2015 on issues the court does not care to read and understand under that act. And so we are back to the High Court, and the High Court is telling you, but the Supreme Court has. Yet the statements of the Supreme Court in that regard were obiter. You know, you have a lot of difficulties in it. So there is a way in which these members are saying, do our judges actually go down there to know what something like CDF is doing. Or they are just in Nairobi. It's bothering them. So I think, Judge, there is a way in which, at my level, I would be requesting as a resolution that we find a way of meeting between the leadership of the judiciary and the leadership of the National Assembly. And we sort out issues, because we don't want to ground either of those institutions. Honorable Judge Ibrahim, there is a time the High Court, if you remember, nullified 23 acts, including the law which had given them money, which they had used for a whole year before. So you are nullifying, do you return this money or what? We've had cases like Gorsongo, where a chair of a committee is speaking within the precincts of parliament to update the nation, and is held to have been, defamatory within the precincts there. And Parliamentary Service Commission has now to come and pay for that member. These members are now saying that if we reach those cases, Parliamentary Service Commission may pay, but it will be cut from the budget of the judiciary. And we don't want those situations. We don't want those situations. So there is a thinking that the judiciary is going deep